So let's just imagine for a second you get served with a lawsuit. That big official looking stack of papers lands in your hands. It's pretty intimidating, right? But what you do next, well, that's absolutely critical. Today, we're going to break down a defendant's first and maybe most important moves in the whole chess game of a lawsuit.
All right, the complaint is there, staring you in the face. The clock has officially started ticking. The plaintiff has made their opening move. The ball is in your court. So what's your first official response going to be?
Okay, so after any initial attempts to just get the case thrown out are dealt with, your main job is to file a formal document. It's called an answer. This is your chance, your very first opportunity to go on the record and respond to every single thing they're claiming. And for every single numbered paragraph in that complaint, you really only have three basic choices. You can say, yep, that's true, and admit it. You can say, nope, not true, and deny it. Or you can say, honestly, I don't have enough information right now to say one way or the other. And that's pretty much it.
I mean, that sounds pretty straightforward, doesn't it? Admit, deny, or I don't know. But here's the thing. Just filing a simple answer like that is like showing up to a sword fight with a butter knife. Sure, you're defending yourself, but you're not really setting yourself up to win.
And this is the real secret sauce. A truly smart legal strategy is about way more than just reacting. The source material is crystal clear on this. A wise defendant will always file something extra, this powerful tool called affirmative defenses. This is where the game really begins. You should think of affirmative defenses as your strategic shield and honestly, maybe even your sword. See, this isn't just about saying, nah, I didn't do it. This is about you bringing a whole new set of facts to the table, new arguments that can completely wipe out the plaintiff's case. So what exactly is an affirmative defense? Put simply, it's you saying, hey, you know what? Even if every single word you're saying about me is 100% true, I still win. And here's why. It's new information that, if you can prove it, gives you a legal get-out-of-jail-free card. It is a total game changer.
Now, these terms might look like a bunch of complicated legal jargon, but the ideas behind them are usually pretty simple. For instance, statute of limitations just means they waited too long to sue. Accord and satisfaction could mean, hey, we already settled this problem. Each one is a unique weapon that can stop a lawsuit dead in its tracks. So this whole back and forth with the complaint, the answer, and these affirmative defenses, it's not just shuffling paper. This is the process of drawing the official battle lines for the entire fight to come.
You can see the flow, right? It's like a little dance. The plaintiff leads with their complaint. You hit back with your answer and your affirmative defenses. Then the plaintiff gets one last word in this opening round, a reply, where they respond just to the new defenses you brought up. And once that final reply is in, bam, we hit a major milestone. The legal term is that the pleadings are now closed. What that means is the first phase, making all your claims and counterclaims, is officially over and locked in. And you cannot overstate how important this is. These documents now form the official map of the dispute. Anyone, especially the judge, can look at them and see exactly what the plaintiff has to prove to win and what you have to prove to win. The rules of engagement have been set. So, the battle lines are drawn. We know what everyone is arguing about. But how do you go from just making allegations on a piece of paper to actually proving them? Well, that brings us to what happens next.
So anything you admitted in your answer, that's now considered a solid fact for the rest of the case. It's off the table. But everything you denied, that's where things get interesting. Each denial creates a contested issue, something that has to be proven, and you resolve that through a process called discovery. And discovery is basically a giant, mandatory fact-finding mission. It's where both sides get to dig for evidence. We're talking documents, emails, testimonies, you name it, all to prove the allegations they made in their pleadings, and, just as important, to expose the weaknesses in the other side's story. You know, with all these documents and procedures, it's pretty easy to get lost in the weeds. But if you zoom out, the ultimate goal of any lawsuit can actually be boiled down to a super simple, really powerful three-step mission. That's it. That's the whole game in a nutshell. Make the court see that you should win, and then get the court to make it official with a judgment in your favor. And you do it in 3 steps. First, you allege. This is everything we've been talking about so far. It's the pleading stage, using your answer and your affirmative defenses to put your side of the story on the official record and draw those battle lines.
Second, you prove. This is that discovery phase we just touched on. You're no longer just making claims. You're out there digging up the actual, admissible evidence, the hard facts, to back up everything you allege.
And finally, you move. This means you take all that proof you've gathered and you formally ask the court. You literally file a motion to take action and enter that judgment in your favor. Allege, prove, move.
So, the foundation is laid, the allegations are made, the mission is clear. But that second step, prove, is a whole world unto itself. In that intense, often brutal process of discovery, how do you actually find the evidence you need? How do you expose who's telling the truth and who's bluffing? Well, that is where the real fight begins.